So we're going to talk about the First Amendment. We're going to start by talking about specifically the First Amendment, then we're going to talk about First Amendment and video games. A little bit of background here. So I've already got the introduction, so I'll skip that. A few disclaimers. This is going to be a very high-level overview. I'm going to talk at a pretty rapid pace to get through the material. The First Amendment is a topic you can take an entire law school course or 2 or 3 on, and I'm going to try to cover it in 20 minutes. So we're going to go really fast. The opinions that I'm giving you, if there are opinions here, they're my opinions. They're not the opinions of my clients or IGDA or anyone else. Finally, and this is the one you'll get from every lawyer who gives a presentation ever, I'm not your lawyer. This is not legal advice. So the basics of the First Amendment. So this is the text of the First Amendment on the screen. I'm not going to read it to you. I am going to say it protects a bunch of things. We're going to focus today on just a couple of them. Congress shall make no law abridging the freedom of speech. So what does that really mean? So freedom of speech is actually a little bit of a misnomer. It protects freedom of expression. Speech and expression are interchangeable in the law. Why do we protect the freedom of expression? So there are a couple of justifications here. One is that we want to encourage citizen participation in democracy and in society. One is that we want to encourage a marketplace of ideas so that people can find the best and strongest justifications for their actions in life. And the third is that it's just fundamentally an individual liberty. What doesn't the First Amendment protect? First, it doesn't protect fraud. So if, for example, you say, this game is going to have 32 playable characters if you pay $300 on Kickstarter, and you know from the beginning that you're never going to have 32 playable characters, that's not protected. By contrast, if you say this game is going to be great, and you know from the beginning that it's going to be kind of crap, that's not fraud. That's just advertising. Defamation. It doesn't protect you if you go around saying that I steal money from old people. That's not protected speech. I don't steal money from old people. You're hurting my reputation. You're lying. Not protected speech. Fighting words. If you say to a police officer, why don't you pick on somebody your own size, pig? That's not protected speech. Those are fighting words intended to bait someone into punching you. By contrast, if you say to that same police officer, I don't like you, or you're a pig, those are not fighting words, because they're not intended to bait a response. The third, clear and present danger, this could be, you could view this as a national security kind of exemption to the First Amendment. It doesn't protect you if your game or your app is a way to encourage people to commit treason or take action against the government or join Al-Qaeda. True threats, if you say, I'm going to kill you, or I'm going to kill the president if he passes this law, those are not protected phrases. You cannot threaten people under the First Amendment. By contrast, again, insults, saying I don't like you, is protected. Fifth, obscenity. Child pornography is the classic example of obscenity. Obscenity is something that appeals to a base, prurient interest. It's really the worst of the worst content that you can imagine falls into obscenity. What is not obscenity is regular pornography, vulgarity, or offensive speech. None of that qualifies as obscenity. Another exemption to the First Amendment is the infringement of another person's rights. So if you copy my trademark or my copyrighted work, you breach a contract through disclosure of a trade secret, or you invade my privacy, none of that is protected under the First Amendment. There are exemptions to that exemption, which would be fair use or fair reportage, those kinds of things, which we'll talk a little bit more about. And then non-speech conduct, so for example, driving is conduct that is not speech. The government can regulate it all day long. By contrast, there is speech conduct, such as taking a knee before a football game. The government could not pass a law that makes that illegal because it's speech conduct. We'll talk a little bit more about that. So why are each of these things important? You can see the green area there is protected free speech. Every time we create a category of something that's not protected free speech, or every time we regulate something out of that definition, the amount of protected free speech is diminished. So we look again at Congress shall make no law abridging freedom of speech. So again, what's not protected? Congress shall make no law. So if it's not the government acting, Congress has been interpreted to also mean state government. But if it's not the government acting, if it's a private actor, there's no First Amendment protection. So for example, if Apple or Google refuse to put your app in the marketplace because they don't like the content, that's not protected. If Steam similarly refuses to put it in the marketplace, that's not protected. The ESRB and PEGI I include here to mention because if, for example, you get an adults-only rating, you've essentially been censored out of most of the major marketplaces and most of the major retailers. The ESRB is not a government actor. The ESRB is a private voluntary association that you pay to get your game rated from. But yet it can have a censorious effect if they refuse to give you the rating you want. Or if you can't afford to get the rating and Microsoft or Sony or someone else is requiring you to have that rating to get published on that platform. So again, abridging the freedom of speech, if there is a government regulation that applies to one of these non-speech items, that's not going to be protected by the First Amendment. So what does protect mean when we say protected by the First Amendment? In short, regulation. If there is a government-imposed regulation or a court-ordered restraint, that's where the First Amendment would step in and say, hey, wait, let's take a step back. Maybe we can't do this. So for example, if I sue you for copyright infringement and the court orders you to stop distributing your material because I've said it's copyright infringing, the court is the one telling you to stop. And that's where you have a court-ordered restraint, and the First Amendment has to be balanced against your rights. Protected speech can still be regulated. So even if you're in squarely a protected category of speech, you're making a political speech on a stage, it can still be regulated. It's just that there's a higher level of scrutiny for regulated speech than unregulated speech. So if it's protected speech, it's a content-based restriction, meaning the restriction says, if you say this, we're going to regulate you that way. That's strict scrutiny. Strict scrutiny means that the government interest has to be a compelling interest, and the test that you use to determine if the regulation is justifiable in light of that compelling government interest is the regulation too broad, too narrow, or unnecessarily burdensome? The regulation has to be very narrowly tailored. And if it's content neutral, intermediate scrutiny would apply. Content neutral would be, instead of looking at what you're saying, they look at how you're saying it. So things like, you're putting newspaper machines on a sidewalk. You can put them within 15 feet of an intersection, but you can't put them within 5 feet of an intersection. Content neutral, they don't care what your newspaper says, that kind of thing. So the test here is that instead of a compelling government interest, it just has to be an important government interest. Instead of being narrowly tailored, you just have to have it be tailored to be the least restrictive possible. So it can still be narrowly tailored. It can't be too under-inclusive. So if you're not regulating enough to accomplish your purpose, it's not narrowly tailored. Here, intermediate scrutiny says, even if you're not regulating enough to accomplish your purpose, that's still acceptable. So the First Amendment and video games. Now we'll get into the games, which is why you're all here. So Brown v. Entertainment Merchants Association, otherwise known to most onlookers as the first Supreme Court case to mention Mortal Kombat. Basically, this was a California case, a case out of California. California had enacted a law that was going to prohibit the sale of violent video games to minors. There was a whole set of definitions for what a violent video game was, what a minor was. The industry groups, including the Entertainment Merchants Association, sued the state of California to invalidate the law. Eventually, after working its way up through the chain of appellate courts, it reached the US Supreme Court in 2011 and was decided. Mostly significant because it's the first case in history to say that video games are protected free speech expression. So what that means is that you have to hit that higher level of scrutiny to regulate video games. But of course, even protected speech can still be regulated. So the court had a couple of key takeaways here. First, it said that violent video games are not obscenity. Remember I mentioned that obscenity has to appear to a prurient interest. It has to be really terrible. It has to appeal to the worst levels of humanity. And it can't have any redeeming social value. The opinion in this case said video games don't fit that category. Even if they're violent, they're not obscene. Secondly, the court said that California didn't have a compelling interest in regulating this. So basically they said, the state had argued that they needed to protect children from psychological harm, and they needed to assist parents in the control of their children. The court rejected both of those arguments, saying first that the evidence they had submitted, that the state of California had submitted to say that there was psychological harm was based on clinical studies where the experts on the other side had said, these clinical studies really aren't that great, they're pretty shoddy. And secondly, The ESRB, which already existed, provided parents with a way to keep their children from accessing content they shouldn't. There was an easy label to understand right on the cover, and it wasn't necessary to achieve that. In order to achieve that interest, you didn't need to have this additional regulation banning the sale outright. And third, they said even if the state had that compelling interest, the law was not narrowly tailored enough to meet that. So it was over-inclusive in that it didn't prevent, or it did prevent children from seeing the content who didn't necessarily need to be prevented. So they already said, parents get to make this decision, but then they banned the sale to all minors. So if your parents didn't care, you were still prevented from seeing it. And secondly, they said it was under-inclusive because it allowed parents to opt out, so parents could still buy those games for their children. And if the goal is to keep children from seeing them, you're not really meeting that goal by allowing parents to buy them. And secondly, it allowed non-video game violent media. So you could have the most violent movie on the planet, and Best Buy could have sold that to minors, but they couldn't have sold, Grand Theft Auto. So the current landscape arising out of that decision, or following that decision, is that games now are more realistic and more immersive. So why does that matter? So Brown v. EMA was a 5-2 to 1-to-1 decision. So it was reported as a 5-4 decision, or a 7-2 decision, meaning that you have 9 justices on the Supreme Court, 7 people said, we don't think that this regulation should stand. But 5 of those people were the ones that said, free speech, the regulation's too broad, et cetera. 2 of them basically said, in this instance, we think that this law is overbroad. But we could see another law that would regulate this, and we could see future technology applying in a way that would make it so that video games should be regulated in this way. They both hinged on the fact that video games and things over time become more realistic and more immersive. And now we're there. They're more realistic and more immersive than they were 6 years ago in 2011. The 4 dissenters, or the 2 dissenters, of them, 1 said, go ahead and regulate it. Fine, video games aren't speech. And 1 said, go ahead and regulate it in this way, this is acceptable. And since that decision, we now have a new Supreme Court. We've had 1 justice die and be replaced by another. And interestingly, this did not break down on party lines. So the former Justice Scalia, the one who died, was in the majority, which was the side that said we should not allow this regulation. And he has been replaced by a more conservative justice, but the more conservative justice could very well side with the liberals again to come out the same way, but we don't know. We also still have the ESRB in place. We still have a voluntary ratings group. A couple of examples of things that have happened in foreign countries. Grand Theft Auto has been banned in a number of countries, mostly for its violent or sexual content. Command & Conquer Generals, Battlefield 4, and Football Manager 2005 have all been banned in China for their depictions of the Chinese government or for representing Taiwan and Tibet as part of or not part of China, depending on the political view of the regulator. So it's important to keep in mind that while these things seem foreign to the United States, in other countries there are these bans happening. So Pokemon, it's not just about violence. Pokemon, banned in Saudi Arabia. And Manhunt 2, a game where you hunt other men, is banned in a number of countries for the violent content. So the current landscape, to keep it going, we live in an era now where the president has attacked the media for being fake news, where he has made veiled threats at individual reporters, and where he has called free speech and the very idea of it disgusting. He's also suggested opening up libel laws, which opening up is up to your interpretation. He said nobody should be allowed to burn the American flag, which the Supreme Court has said is free speech. He has called fake news he has used the term fake news to apply to specific well-reported stories. He's called for firing of individual reporters. He has called individual stories lies, and he has said that 90% of the fake news, or 90% of the media is fake news, and then praised certain parts of the media. All of these tweets that I've just posted came from the month of December. So he's done a lot of things against the media. So that's important to keep in mind in this landscape. And the last thing that he's done on Twitter is banned people who speak against him, which is explicitly prohibited by the First Amendment. But that doesn't seem to affect the behavior. So now we'll move to games as resistance. So this has a long history. So in 1904, there's a board game called the Landlord's Game that is basically the predecessor to Monopoly. The Landlord's Game essentially functions as a way to make players realize the disproportionate power that landlords have in the 1904 economy. You play, and the more land you get, the wealthier you get. If you never get the land in the rolls around the board, you're never going to win the game. You're going to lose the game. You're going to end up paying all of your money to the one guy who got all the land on the first pass around the board. A couple of other examples, Papers, Please and Orwell are both more recent. These are video games where you play as some sort of government actor, and the idea here is to allow the player to take a role to show the player what challenge the government actor has, but also to make the player empathize with the individual government actor who's placed in this situation by their government. So in the example of Papers, Please, a border agent who has to decide whether or not to allow someone into the country, simultaneously weighing that person's human story with the concerns about terrorism or smuggling that the country may have. Another example is the Games for Change movement. This is a movement that encourages people to produce games with political or social messages. So a couple of examples here. Lilia and the Shadows of War is another game about empathy, as is We Are Chicago. Lilia and the Shadows of War is by a Palestinian designer, basically designed to make the player empathize with the idea of the choices that you have to make to feed and sustain your family when you live in a war zone, and how much different that is than when you are just playing in a normal zone, or you're living your life in a normal, non-conflict area. We Are Chicago, similarly, seeks to make the player empathize with people who are living in a gang-ridden area of Chicago. Thunderbirds Strike, this is an example I include because I like the reaction. So Thunderbirds Strike is a 2D side-scroller where you play as a Thunderbird that can shoot lightning bolts to stop the spread of oil pipelines and drilling in the oil sands of Canada. So why do I include this here? The reaction from the oil industry was to call this game out and say that it promotes eco-terrorism. And they tried to get this game shut down. Now, fortunately, this game wasn't being distributed on Steam. This game wasn't being distributed in the Apple Marketplace. It was literally just being distributed for free on the developer's website. So what these stories actually did was encourage people to go out and play a game they probably otherwise wouldn't have even known about. But it's just an interesting reaction and another example of the scrutiny that games can come under. So another, just a little bit more on the importance of this, the importance of resistance here. Brown v. ESA, all of these quotes here are from the opinion. Basically, this is talking about the progress of technology, starting with the 1800 and dime novels and moving all the way through comic books and television. The next logical step was video games. As video games and VR become more and more immersive again, that's going to become more important. The limits of free speech are defined by the fringes of the free speech. So as we allow free speech rights to be taken away, we end up having fewer free speech rights, and getting them back is incredibly difficult. We've been fortunate that the Supreme Court has sided on the side of the First Amendment for a long time. There's always a shifting balance on the court. It's impossible to know where they are. So with that in mind, go create, be mindful, experiment. I say this with a full heart and support for this industry. You can make games that encourage political change. You can make games that do encourage social change. And by doing that, the next time the Supreme Court case comes up, for every Grand Theft Auto that's out there, there will be a game that the other side can point to and say, this game has redeeming value. I would argue that so does Grand Theft Auto. 80-year-old Supreme Court justices don't necessarily see it that way. So make games, make art, make things that can be used to support an argument that they should continue to be and should always be protected by the First Amendment. So with that, I'll open the floor to questions.
Yeah, if a game developer is working on a game that they know may be controversial, is there steps they can take before publishing, or any recommendations you would make for actions for them to take to prep for any controversy or any legal action?
Yeah, so the question was, if a game developer is working on something they know is going to be controversial, what steps should they take to prepare for that? So I would say it kind of depends a little bit on the controversy. If the controversy is going to be one that is mostly political in nature, I would say use it to your marketing advantage. Play it up, spin it, and then make sure that it's well known in the media before you release the game, because people will buy the game specifically because of that. If it's one that you are worried that it's going to be viewed as a potential harm to someone, that's a whole lot different. And I would say in that case, consider not making it, really. Pushing the boundaries is important. Pushing the boundaries in the way that is responsible and ethical, I think, is more important. So pushing boundaries on issues that matter and not in a way that is directed to harm a particular person or a particular audience is really not productive. All right. Well, I think we're out of time, so we'll let the next presenter come up.